Welcome, dear learner. You are welcome on this SWAYAM platform where we are with the course Understanding Competition Law, Theory and Practice. I am your instructor, Dr. Mayank Pratap, Assistant Professor from Faculty of Law, Banaras Hindu University. And we are taking this last module of this particular course, and today we will take the last session of this last module where we will deal with the competition law and its relation with the other subject, so that the topic is competition law and interplay, and the interplay obviously means the other subjects like the Consumer Protection Act and the IPR. So with this we will discuss the aspects of the competition law with other subject. So before going into detail, if you remember the last or previous session, the previous lecture, we have discussed two important points. We have discussed the two important, you can say, scheme, or you can say the important aspect of the competition commission, which is the basic aim and object, and that was the leniency program or leniency scheme and competition advocacy. If you remember, in last session we have discussed the competition advocacy. Competition advocacy is, you can say, the fourth important pillar of the Competition Act, which is the one of the basic objective of the competition law, which sustain or promote the competition within the market in India. Competition advocacy is like the one of the program to increasing awareness between the competitors, that means between the, you can say, consumer, enterprises, stakeholder and civil society, for the purpose of promoting the competition culture under Indian market system, and which preliminary given under section 49. Competition advocacy complements the like the CCI's enforcement role of proactive engaging stakeholder, business, consumers, policymaker and regulators, that is for the purpose of to create environment conducive to fair environment. And on the other hand, we have also discussed in last session the leniency program. Leniency program is an important program, just like as a whistleblower scheme, under which a person, even who has information, even as a member of cartel, can disclose the true information and cooperate with the CCI to identify if any type of cartel activities is going on. And in reward, as a reward in return, he will may be awarded as immunity, and immunity may be 100%. So what we have discussed, particularly section 49 and 46 with the schemes like the competition advocacy and leniency program in last lecture, and today we'll take the next, or the, you can see, the last unit or the topic of this course, and where we will discuss the interrelation between the Competition Act and consumer protection, because there is sometimes very confusing. Dear learner, you must have a question on your mind, how Consumer Act, Protection Act, whether it is a different, for what purpose Consumer Protection Act? If the Consumer Protection Act for the purpose of the consumer, the awareness of the consumer, for the enforcement of right of the consumer, and there are the consumer forum available for the consumer, why is Competition Act? Definitely Consumer Protection Act is for the consumer, but you must know that that is particularly for the consumer. On the other hand, what we are dealing in this course, that is Competition Act. Competition Act is a fora, not for exactly for the consumer. That means consumer is the ultimate object of this act, whether it is for the a person who is a manufacturer, who is the retailer, entertainer, that is type of the in anywhere in supply chain, that is not ultimately consumer in this. That means everyone is consumer under this act, not only who consume the finished product. So it is a very important aspect to promote the competition culture between the person engaging in any business, whether it is any person, enterprise, association or person, and even engaging any type of the business activity where like the supply, restoration or the manufacturing, distribution or anything. So with this, if you see, the Competition Act 2002 and the Consumer Protection Act 2019 are the cornerstone of the legislation in India that works in tandem to promote fair market practices, promote consumers' interest and ensure economic efficiency, While Competition Act enforces the CCI focuses on fostering market competition by curbing anti-competitive practices, and Consumer Protection Act administered by the CCPA, that is Central Consumer Protection Authority, and consumer commissions address individual and collective consumers' grievances related to unfair trade practices, defective goods and services. Their interrelation lies in their shared objective of enhancing consumer welfare, preventing unfair practices, and promoting market transparency, with each complementing the other through distinct and synergetic mechanism. However, differences in the scope, enforcement and remedials highlights their unique role. If you see the Competition Act 2002, which ensure, that means the preamble or basic objectives, ensures competitive market by preventing anti-competitive practices, prohibiting the abuse of the dominant position by the enterprises, or regulation of merger and amalgamation, that is combinations, which for the purpose of consumer interest. The CCI, the body which is supported by the DG for the purpose of investigation under section 16, may impose the penalty under section 27 and have the power under this act, like the NCLT under section 53 for the purpose of appeal. So how the consumer relevance, what are the consumer relevance with the Competition Act? If you see, basically Competition Act is not for the purpose of directly which directly intervene or interfere with the material, any material fact or the rights or remedies or grievances related to the consumer, but of course indirectly protect the consumer by ensuring the competitive markets, which leads fair prices and the choice. That means ultimate goal is the consumer welfare, what is not directly related but indirectly it is related. If you see the Consumer Protection Act 2009, the basic purpose and the key component and the you can say the statutory provision we have discussed about the Competition Act. So I am just here to that means what are the key element or provision of the consumer protection. If you see, the basic purpose is safeguards consumers' right by addressing unfair trade practices, defective goods, deficiency in service and misleading any type of advertisement, which ensuring the redressal and accountability. If you go through the key provision of the Consumer Protection Act of 2019, you will find that there is a section 2 subclause 9 which defines the consumer right. Section 10, which is about the establishes the CCPA to regulate unfair trade practices and false advertisement. Section 35 to section 39, which setups about the consumer dispute redressal system even at the district, state and national level for grievances adjudication. Section 29 of the Consumer Protection Act empowers the CCPA to impose penalty, recall product or issue ceases and desist orders. Section 89 prescribe penalty for misleading advertisement, which is up to the 10 lakh. The enforcement, like the CCPA regulates market practices, while consumer commissions provide judicial redressal for complaint, and consumer relevance of the Consumer Protection Act is basically the direct address the consumer grievance. That means it is the act which is for the purpose of to address the consumer grievance directly, which offer remedies to the consumers directly by its forum in the form of refund on compensations. So what is the basically interrelation between the Competition Act and Consumer Protection Act? You can see the interrelation between the two acts is evident in the shared objective, complementary mechanism, overlapping jurisdictions and cooperative framework, which creates or creating a robust ecosystem for consumer protection and market fairness. Consumer welfare, it is ultimate goal of both the act. So the shared objective is consumer welfare. How? The Competition Act creates a competitive environment that benefits consumers broadly, while the Consumer Protection Act provides targeted remedy for individual grievances, reinforcing CCI's consumer protection mandate, which is under Section 18. Prevention of unfair practices. The both Act tackle unfair practices with CCI focusing on market-wide distortion and the CCPA on consumer-level violation, creating a dual regulatory framework. Market transparency and fairness. The Competition Act enhances transparency through advocacy under Section 49 and penalties for deceptive practices Consumer Protection Act, which promotes transparency by regulating ads and ensuring accurate product information, Section 21. That means both the law foster trust by ensuring market operate fairly and transparently, benefiting consumers and ethical business. One more important thing for the comparison for the purpose of the interrelation between the Competition Act and this Consumer Protection Act 2009, you have to see the mechanism, the enforcement mechanism or the redressal mechanism. The enforcement mechanism under the Competition Act or the redressal mechanism under the Consumer Protection Act 2019. If you see the Competition Act, which focuses on the enforcement or the enforcement mechanism through investigation only. Section 26 are there for the purpose of the investigation, which may lead by the Director General, what we have discussed in previous lectures, so details not needed here. The penalties under Section 27 and the remedies like the seizure and desist order. For examples, CCI's action in cement cartel case 2012 restored the competitive pricing, as we have also discussed in previous sessions, so that it is not detail is required here. And on the other hand, Consumer Protection Act emphasizing the redressal through consumer commissions, Section 35-39 and CCPA interventions, Section 21 for refund or compensation. For instance, a consumer commission order a refund in Sharma versus Samsung 2023 for a defective appliance. How it is interrelated? CCI prevents systematic harm that lead to consumer grievances, while the CCPA and the commissions provide direct remedy ensuring comprehensive protection. And the compensation mechanism, if you see under this act, under the Competition Act allows compensation claim by the NCLT under Section 53N for anti-competitive harm through underutilized. And Consumer Protection Act, if you see, provides direct compensation through consumer commissions under Section 39-59, and the interrelations are the Competition Act addresses wide harm like cartel-induced price hikes, while Consumer Protection Act tackle individual losses, offering complementary redressal options. So conclusively, what you can see under the interrelation between the Consumer Protection and Competition Act, that the Competition Act 2002 itself was formulated to ensure a fair and competitive environment in different market to avoid giving rise to the possibility of the formation of monopoly. It ensures free trade and promotes competition. Merger and acquisition, dominance and agreements made by companies are closely monitored by the Competition Commission of India to prevent any anti-competitive practices. The Consumer Protection Act 2019, on the other hand, protect the consumers from the effect of such practices upon consumers in form of unfair trade practices, restricted trade practices, misleading advertisement, unfair pricing, etc. There is a case what we have discussed already in previous session, that is Builders Association of India versus Cement Manufacturer, which is known as the cement cartel case. The Competition Commission of India held that cartelization of cement manufacturers amount to an anti-competitive agreement. Now the important fact is here, which focuses on the interrelation between two. What CCI said that the cartelization of cement manufacturer amount to anti-competitive agreement and imposed penalty accordingly. But this cartelization had also subsequently lead to inflated price and consumer is affected by that exorbitant price, so they could file a consumer complaint at the appropriate forum. So this case focuses or explain the interrelation between the both. So with this was between the interrelation, that means between the Competition Act and the Act Consumer Forum. Now again, let's deal with one more important subject, which is with the interplay between the both is become important. That is interplay between the intellectual property rights and competition law. Intellectual property rights governed by the statute like the Patent Act, Copyright Act, Trademark and Design Act, and the Competition Act enforced by the Competition Commission of India is delicate balance between the incentivizing innovations through exclusive rights and ensuring competitive market by preventing any anti-competitive practices. So the important point is, if you see the role of the CCI for what purpose and objective of IPR is for what purpose. Sometimes both are in contravention. That's why the interrelation is important, just to balance for the consumer or the person's interest. That means a person who is the holder of IPR and the person who are engaging in business. So IPR grant creators temporary monopoly to reward innovations, but their misuses such as the restrictive license or abuse of dominance can harm competition, necessitating the CCI's oversight. This relationship is harmonized through specific provisions, enforcement action and advocacy, ensuring IP rights align with market fairness and consumer welfare. The Competition Act accommodate IPR through Section 3 subclause 5, which exempt reasonable conditions in IP agreements, protecting the rights under specified IP laws from prohibiting on anti-competitive agreement under Section 3, provided that do not harm the appreciable adverse impact on competition. For examples, the patentee licensing agreement with royalty clauses is exempt unless it includes the restrictive terms like the exclusive dealing. However, if you see Section 3 subclause 5, what we have discussed in previous module, that it does not shield abuses of dominant position under Section 4, enabling CCI to address practices like excessive royalty or refusal to license. In a case, Micromax versus Ericsson in 2012, CCI investigated Ericsson's high royalty for a standard essential patent mandating fair and reasonable and non-discriminatory, that is FRAND terms. And in Roche 2017 case, the CCI scrutinized the patent misuse to block generic drugs, complementing to Patent Act compulsory licensing under Section 84 to ensure affordable access. Again, in a digital market, if you see, where IPs like the software's patent often underpins dominance, the interplay is become critical. The CCI against action under the Google case, if you remember, we have also discussed this case in the relevant lecture, for leveraging and rights patenting system to the favor its app under Section 4, illustrates how competition law curbs IP driven anti-competitive behavior. So, if you remember the amendment of 2023, which strengthened this oversight by enhancing CCI's digital market scrutiny, the both law frameworks share the goal of promoting innovation and consumer welfare. The IP law incentivizes the creative, while Competition Act ensures IP rights do not stifle compensation or inflate price, as seen in pharmaceutical and telecom sector. The key points are, for the just understanding between the both the interplay, the complementary objectives. That means both law aims to promote innovation and consumer welfare, but in a different approach. IPR protection is important. IP law grant exclusive right to creators and innovators, while the Competition Act ensures these rights not misused or restricted competition. Abuse of dominance, the Competition Act prohibits the abuse of dominance, including those arising for IPR. Anti-competitive agreement is an important aspect where Competition Act prohibits any type of agreement which may like the anti-competitive or whether it is related to IPR such as patent, pooling or licensing agreement. Balancing Act, it is an important, that means the Competition Act and IPR laws need to strike a balance, and the section 3 subclause 5 is important. If you remember, while dealing with section 3 subclause 5, we have dealt some exemption clause under section 3(5), and the IPR issues we have already dealt with. This section protects the IPR's holder right while also ensuring they don't abuse their dominant position. And section 4 prohibits abuse of dominant position, including those arising from IPR. So more or less we have already dealt with this IPR section while dealing with the anti-competitive agreement, particularly in this session where we have discussed the exemption and exceptional clauses. So as an implication of the both act, you may say that innovation promotion, a balance between IPR and competition law can promote innovation and consumer welfare. Market competition, effective enforcement of competition law can ensure that IPR holder do not misuse their market. Consumer benefit, which is ultimate benefit, the interplay between the IPR and competition law can benefit consumers by promoting innovation, competition and access to goods and services. So in conclusion, to sum up, in summary, you can say this relation between the Competition Act and IPR, it is a complex requiring a balance between the protecting IPR and promoting competition. So while dealing with the interplay with these, as a last aspect in this last session, if you see, we can deal with the what are the contemporary issues and challenges under the competition law, because we have already discussed all the aspect, each and every important aspect of this competition law. So after this assessment, there are certain issues where we have to focus for the purpose of the analysis of the efficiency of the competition law. So for that purpose, there are 4 or 5 points, which is an important aspect, like the enforcement challenges. The CCI faces difficulty in enforcing competition law, particularly in technology-driven sector where market dynamics evolve rapidly. For instance, investigation into the companies like Google and Apple have slow and actions have been insufficient and delayed. Leadership and staff issues are there, like CCI has struggled with leadership vacancies and inadequate staffing, which hampers its ability to resolve the cases and prevent anti-competitive practices. As on October 2022, the CCI had issued only one order under Section 26(1) of the Act and none under Section 25. So this is an important issue, like the lack of staff, which is a great challenge for that purpose. Monetary penalty collection is important. That means CCI has imposed penalty totaling 18,351.64 crore rupees since 2011. This is old data which is available on the website, but only managed to collect 2.3% of total amount, but relevant because of to conclude the what happened actually the collection. So which is 425 crore. This raised concern about the effectiveness of CCI's enforcement mechanism and regulatory framework, which is an important challenge. The CCI faces challenges in keeping pace with rapidly evolving market dynamic, particularly in digital ecosystem. The regulatory framework needs to be updated to redress the complexity of modern business practices. So these are the important aspect which is even relevant today for the purpose of to take it, you can look at a challenge. There are some more small or important, small but not least, that means very important aspect as well, like the technical expertise. The CCI requires specialized knowledge to identify and address the anti-competitive behaviors in complex market. For example, understanding the algorithm is important, and for that purpose, a technical expert is required. The CCI's efficiency in resolving the cases led to loss of consumer trust in regulatory process, that is because of the delay process. So for that purpose, to redress the issues, this is an important aspect to tackle with the challenges, and of course the insufficient political supports are there. So these are the technical and the you can mechanical or infrastructure, behavioral. There are some types of challenges which may be addressed. So with this, I am leaving this session with a question for you to think over this. And the question is, what is the primary objective of the Competition Act in relation to intellectual property rights? The options are to restrict the grant of IPR to promote competition, to protect IPR holder from competition, to balance the protection of IPR with the promotion of competition, to eliminate IPR in the market. So this is a question for you. You may think over it and you may identify the answer. So with this, I am not leaving only this session, but this course which have been completed for today, not but for the whole course. So thank you very much, and hopefully you will enjoy and you will find the maximum benefit of this course through SWAYAM platform. So thank you very much.